Hello everyone, I'm here on my English Law channel. So this video is about human rights and parliamentary sovereignty. So I've laid out how Professor Albert Venn Dicey, at the beginning of the 20th century, he's the main advocate for really illimited parliamentary sovereignty. There are judges, as we shall see, who say that in certain circumstances that courts might actually block some statutes, although that's quite contentious, hasn't happened thus far. So the Human Rights Act passed in 1998 was a real watershed in English law, and that domesticated the European Convention on Human Rights, which the United Kingdom signed in 1950. So the HRA that took effect in the year 2000, and this touches on many civil liberties issues. So the Human Rights Act, as it says in its preamble, was intended to give further effect to the rights and freedoms guaranteed under the European Convention of Human Rights. So that's almost all those rights in the ECHR were then part of domestic UK law, and courts within the United Kingdom could adjudicate on these rights rather than these issues having to be sent to the European Court of Human Rights at Strasbourg, not to be confused with the European Court of Justice at Luxembourg. So the European Court of Human Rights is not a European Union court, as a common misconception, whereas European Court of Justice is an EU court. Think about the ECJ is the proper name is going to be the Court of Justice of the European Union. Anyway, so the human rights isn't entrenched as such, and it tries to maintain parliamentary supremacy whilst protecting rights. So it was drafted in a way so as not to undermine parliamentary sovereignty. That's the idea. And a Lord Justice Judge said the Act is carefully drafted to ensure that the court cannot and must not strike down or dispense with any single item of primary legislation. That came up in R. Ray K, a child, a 2001 case. Ray means thing in Latin, it's about. K, because sometimes children have to be anonymous in cases they're just known by a letter. And so that Lord Justice, what a great surname he had for being a judge. His surname was Judge. Nominative determinism, no doubt. So in many court cases, many other countries, courts can nullify legislations. For example, the Republic of Ireland, the United States, they can do that. So there are some clauses of the Human Rights Act the courts would have to think about. Section 3 introduces a new interpretative duty on the courts, and Section 4, which allow the courts to issue a declaration of incompatibility. So Section 3 says that the courts must read all legislation, primary and secondary, in the light of the Human Rights Act, insofar as possible, as in to try and make it compatible with the Convention. It might not be compatible with the European Convention on Human Rights, these statutes. So in some cases, they have, frankly, imagined words in the statutes which are not there to try and render this legislation consonant with the Human Rights Act. So they put a certain construction on legislation which will render it compatible with the European Convention on Human Rights. So in some situations, it's impossible to do so because it would impose a heavier semantic burden than certain words could bear to try and have an exegesis of this legislation in a manner which is consistent with the Human Rights Act or the European Convention on Human Rights. So anyway, the courts might take an exceptional course, that's what Lord Steyn said it, under Section 4, and issue a declaration of incompatibility, say this statute is incompatible with the European Convention on Human Rights. It's happened but rarely. So the declaration does not make the statute invalid, and that still is the law of the land. But it simply tells that the government that there is an anomaly here. You ought to address it. Are you going to repeal or amend the legislation, or what? And if the government doesn't do so, then the UK is breaking its human rights obligations. So that's set out by late Baroness Hale, who was head of the Supreme Court, just retired, in a case called R. Animal Defence International and Secretary of State for Culture, Media and Sport, the 2008 case. Okay, so anyway, whether the legislation is going to be amended, what's going to do to rectify the situation is up to Parliament. Is the courts don't get to make that determination. We don't have critarchy. Many people would consider that insupportable oppression. So the final decision on whether to change the situation, that's left up to Parliament. So parliamentary supremacy is not thwarted. So being part of the European Union has changed English law, but then after Brexit, some of that legal heritage will be binned. We don't know how much yet. The default setting is that all this EU legislation remains on the statute book, and it could be repealed piecemeal. Some of it is uncontroversial, is perfectly sensible. So they don't want to throw out the baby with the bathwater. You might think the European Union is a wonderful thing. You might want to keep it all. You might want to reverse it. But anyway, this is the situation. Did EU membership undermine the supremacy of Parliament? Eurosceptics usually say that it did. So was it sharing of sovereignty, or was it a surrender of sovereignty? These are the two different interpretations. Remainers would say the former, and Leaves would say the latter. So the European Union was supranational, and there were intergovernmental aspects of it as well. So anyway, if the United Kingdom signs a treaty, that's not part of UK law unless Parliament actually passes a law to say that it is. And the European Communities Act 1972 made the Treaty of Rome part of UK domestic law. So signing and ratifying a treaty are not the same thing. So the European Union was a group of 28 member states. At its apogee, the UK has just left, bringing it down to 27. It's about 4 freedoms: free movement of people, goods, services, and capital. So the EU law took priority over British law. So the Treaty of Rome 1957 doesn't spell that out, but the European Court of Justice, through its jurisprudence in the 60s, interpreted things that way, and then it became crystal clear in a number of cases. Van Gendenlos, but I might tell you about that in lectures on European law. So the European Court of Justice held that when countries signed treaties joining the European Union, or European Economic Community as it was prior to that, the member states had created a new legal order, and they had therefore constrained the competence of their domestic legislatures, and they had granted certain powers to the European Union to legislate for them. And of course, all member states were represented in the European Union institutions. So Van Gendenlos, which I mentioned in 1963, in this famous case, the European Court of Justice said the community constitutes a new legal order of international law for the benefit of which states have limited their sovereign rights, albeit within limited fields, and the subjects of which comprise not only member states but their nationals. End of quotations. So the citizens were subject to this as well, not just the governments. So anyway, it was therefore crystal clear that EU law was supreme. Costa and NL is another case in point. So the European Court of Justice in this case said that by joining the European Economic Community, as it then was, this new legal order became essential to the domestic legal systems of all the member states of the EEC, and they had chosen to delimit their sovereignty in order to participate in this multi-state effort. There's another case in 1970, Internationale Handelsgesellschaft, a German case, West German case. Remember, Germany was divided at that time into East and West. It means international trade company, Internationale Handelsgesellschaft. The European Court of Justice said that the law stemming from the treaty, an independent source of law, cannot, because of its very nature, be overridden by rules of a national court, however framed, without the legal basis of the community itself being called into question. So the court was saying that if the two collide, European law has got to take priority, because if it didn't, that would be the end of the European Economic Community. Remember, the EEC changed into the EU in 1993. So I might say EEC, I might say EU, but I'm meaning the same organisation as it metamorphosed. Simmenthal was another case where the European Court of Justice said that member states were not able to introduce measures that breached their EU obligations. So anyway, the United Kingdom passed the European Communities Act 1972, and that's how the UK became a member of the European Economic Community on New Year's Day 1973. There's the very well-known factor tame case about a fishing boat from Spain, and this made it crystal clear what effect this had on the UK legal system. There's another case, Thoburn case, the metric martyrs from about 20 years ago. Some chap in northern England trying to sell things with in units like pounds and ounces, and because the European Union have to use grams and kilograms, and he wouldn't accept that, and that was breaching EU law. But again, it was spelt out yet again that if the two collide, then EU law will take priority. So it was said to be a constitutional case. Anyway, remember I mentioned about the high-speed 2 case about building that high-speed railway. Okay, so it's a constitutional instrument, and Miller set out how the European Union has a constitutional character. The Miller case, this is a woman who was challenging Brexit. Okay, now the United Kingdom's got a dualist system, as I pointed out, so having signed a treaty, that doesn't automatically make it part of UK law, whereas France is a monist system. So mono as in a one, if you sign a treaty, then it is in your law. You can't have international treaties and domestic law. They're the same in France. Anyway, what was the next thing to point out? So the United Kingdom had certain obligations pursuant to having signed various EU treaties. So the European Communities Act 1972 gave effect in UK law to a certain statutes of EU, EEC law or their court decisions, which had direct effect on the member states, the United Kingdom being one of those member states. After joining the EEC, Westminster was no longer the only legislature capable of legislating for the United Kingdom. So looking at the European Communities Act 1972, it says that all such rights, powers, liabilities, obligations and restrictions from time to time created or arising by or under the treaties, and all such remedies and procedures from time to time provided for under the treaties in accordance with the treaties are without further enactment to be given legal order or use in the United Kingdom. Anyway, it goes on. So that means from 1973, any EU legislation that applied in the United Kingdom automatically. So Section 2 of the European Communities Act said that EU law would be directly applicable in the UK. So the UK no longer being independent in that sense, that was because Parliament willed it. I know a lot of people tell me you can be independent in the European Union, but you can't. Independence can be overrated. The European Union might be a splendid thing, but don't pretend you can be independent in it. If there's some sort of higher legislature which can legislate for your state, country, whatever you want to call it, then your state, country, that entity is not independent. It might have a wide degree of autonomy, but it's not fully independent. Okay, so anyway, Section 2.4 of the European Communities Act says this: any enactment passed or to be passed, other than one contained in part of this Act, shall be construed and have effect subject to the foregoing provisions of law. Okay, so that was bearing in mind that EU law would always take priority over UK law if there was any clash, and these EU laws would in future would automatically apply in the United Kingdom. So this provided for EU law to be supreme, even though that word wasn't actually used in the European Communities Act. So there are EU rights which would have priority over any UK domestic law. And if there's okay, so what attitude do the UK courts have to this? So people talk about a purposive interpretation, interpreting things with a certain purpose in mind. Or teleological, as in teleos, as in distant or far away in ancient Greek. So they're looking somewhere, they're trying to go somewhere, their interpretation. And Eurosceptics was often savage the European Court of Justice for its sort of filling things in, inventing things, legislating. When they say that's wrong, you shouldn't usurp the legislative function. Your function is judicial, just as it would be deeply inapposite of legislators to attempt to usurp the judicial function. Anyway, if there's the courts would try and get around any inconsistency between UK domestic law and community law by being creative, as they say. Community law as a European Union, European Economic Community. Later on, a European Union. So the Merchant Shipping Act 1988 is an example of when things were when there was a clear clash. Factor Tame was a British company which was owned by Spanish people, had fishing vessels, and they're registered as British under the Merchant Shipping Act 1984. But that's to do with the UK's quota, the EU Common Fisheries Policy. You had to let other countries fish in your waters, and you had a quota of how many fish each nation was allowed to catch in these waters. So, but the UK said that this quota should be for British fishermen, should be for really British fishermen, couldn't be foreign owned. So the Merchant Fishing Act was passed saying the British fishing vessels have to be British owned, they can't be Spanish owned, for example. But that was against EU law. So Factor Tame said was not predominantly British owned and said that's unfair. They sought judicial review because this Merchant Shipping Act 1988 was in breach of an EEC treaty. So it was Factor Tame number one, that case, and went to the European Court of Justice. But so while this was going on, the Merchant Shipping Act 1984 had to be suspended, was disapplied for a while. But the long and the short of it was that what the UK government was doing, it was illegal, and again, it underscored yet again that EU law took priority. So the House of Lords looked at it, said it was a domestic law, and then the House of Lords couldn't interfere. They were not going to stop from disapplying the Act. Okay, the House of Lords sent the issue to the European Court of Justice. Could interim relief be granted, as in saying, well, we're not going to disapply the Act for a while. Anyway, so the European Court of Justice said that a national court, in this case the House of Lords, was able to grant interim relief, as in a short-term remedy. They're trying to sort out the issue permanently, and said that a certain national law could be just disregarded temporarily. This is like to do with the Crown Proceedings Act 1947. Said that no injunctions can be granted against the Crown. Was it granting against the Crown? The European Court of Justice said that community law must be interpreted as meaning that a national court could, in a case before is concerning community law, consider that the sole obstacle which precludes it from granting interim relief is, as a rule of national law, must be set aside. So it was possible to set aside a national law, but the case went on. There was R in Secretary of State for Transport ex parte Factor Tame number 2 in 1991. The House of Lords granted interim relief and said the Merchant Shipping Act 1994 is going to be suspended temporarily till we sort this out. So Factor Tame was about setting aside national law because it clashed with EEC law, rendering it inoperative. Lord Bridge talked about supremacy in the Factor Tame case, and he said the supremacy of EU law of national law of member states was not always inherent in the treaties. It's certainly well established in the jurisprudence of the European Court of Justice, long before it joined the United Kingdom would join the European Union. Finished there. So when the UK joined, that was already the case. If there is any clash, then the EU rules take priority over national rules. So Sir William Wade said that Factor Tame was a constitutional revolution, and he said we have supremacy of Parliament. So we can't do this. But then the European Communities Act was in 1972. One Parliament can't ban its successors. Although I'd say, well, if that's the case, then if Parliament passes the Merchant Shipping Act in 1988, if that clashes with the European Communities Act, then the Merchant Shipping Act must take precedence, because the Parliament can't be bound by what it said in 1972. Parliament can change its mind, can break that European Communities Act. Anyway, so Sir John Laws said that the European Communities Act created a rule of construction for later statutes, and any statute has to be read in a way that's compatible with the rights conferred by European law. So this came up in the Miller case in 2016. This was Miss Miller's challenge to Brexit. She's a Remainer campaigner. But this is what the High Court said in that case. There is no superior form of law than legislation, save only where Parliament has itself made a provision for that to happen. The European Communities Act 1972 confers precedence on the European law, and that's the sole example of this. So therefore the European Communities Act was unique, was binding its successors, when no other piece of legislation does that. The Supreme Court in Miller and Secretary of State for exiting the European Union 2017 said that there is nothing in European law which changes the supremacy of Parliament. Parliament could still repeal the European Communities Act, and in a sense did. That's what Brexit is all about. The court said, consistent with the principle of parliamentary sovereignty, this unprecedented state of affairs will last only so long as Parliament wishes. The 1972 Act can be repealed like any other statute. And indeed it was. So there is another law which we should look at, and that's the European Union Act of 2011, which had a declaratory provision about that act. It said directly applicable or directly effective EU law, that is rights, powers, liabilities, obligations, restrictions, remedies, procedures, and so on. The European Communities Act falls to be recognised and available in UK law only by the virtue of that act, was recognised and available in law by the virtue of any other act. Okay, so that emphasised what we already knew, that there's a dualist system in the UK, and the law of the EU is there in the UK because Parliament willed it in the European Communities Act 1972. And this is what the House of Commons Library had to say about it. The government's intention was to affirm that what was said in Thoburn, that an Act of Parliament using express words can repeal the European Communities Act. Remember, Thoburn, the metric martyr, so about selling his fruit in pounds and ounces. A case from about 2000. Okay, so that's enough at the moment on parliamentary sovereignty and the European Union.